Good afternoon, everyone. Can you hear me? Mr. Hi, I'm Judge Pelt. We're here for your bond hearings. Today's not trial. What we're doing is to just determine if there's probable cause for your arrest, and if I find probable cause, then to see if you're eligible to bond out. I'm going to call the docket in the order that my clerk gave me your files. When you hear your name, you'll come up. We'll see how quickly we could help you resolve your cases today. We're going to begin with Liza Longabuco.
North Broward.
Is this where I stand?
Hi, Miss Longabuco. How are you?
Okay.
Okay. You are charged with resisting an officer with violence and without violence, and striking and battery with domestic violence. I found probable cause. I'm going to ask the state for their recommendation of bond.
She had a battery and domestic violence battery in 2006 that was dropped.
Okay, so 500?
Yes.
Okay, so I'm going to set your bond at 500 on count 1, and there's no charge on count 2, and no charge on count 3 as well, correct?
You have to set a bond.
Okay,
on
set a
three.
bond. Okay, so what is your recommendation?
500 as well, Your Honor.
Okay, 500. So your bond is total $1,000. If you could bond
Okay.
out, you could get out today. If not, then you'll see your trial judge in a few days.
Your Honor, we'd also like to ask for no contact with
We'll
the
have a no
victim.
victim contact order as well.
And I'd like to ask, ma'am, did that happen? It looks like your eye is swollen. Did that happen in any regard to police contact? Or was that in the
Yes.
incident? Was that?
No, this was police.
All right, then I'll ask for photos.
Okay.
Thank you, ma'am.
I'll grant that. Okay, Frederick Maddox.
I'm sorry. What did you say after the $1,000 bond? What's the
We're going to get a no contact order for you with the victim, and we're going to also have an order for photographs to be taken of your injuries.
Okay, and okay. Thank you.
Okay, good luck. Okay. All right. Okay, Mr.
Mr.
Maddox?
Maddox is president of Maine, Your Honor.
Yes, ma'am.
Hi, Mr. Maddox. You are
Good
charged
morning.
with, how are you doing? You're charged with domestic violence. I found probable cause. I'm going to ask the state for the recommendation of the amount.
DUI in 2001, battery in 96 out of date, resisting without violence in 94, ag battery on a pregnant female, and a false imprisonment that was dropped in 94. Another battery in 93, dropped.
Counsel.
Possession of cocaine, adjudication in 86.
Counsel.
Your Honor,
Are you here for Mr. Maddox?
Yes,
Okay, and who are you?
I'm his wife,
Okay, and what's your name?
Jamia Alexander.
Okay. When you want to say anything?
Yes, my daughter and I were witnesses to the events that occurred last night. I'm here on his defense.
Okay. You want to say anything?
Amari, stand up. You have to. Well, I just want to say that my husband was defending himself. I don't know what was said to you guys, but we were there. We were witnesses to the events that really occurred. And I just want to say that he was defending himself with the issue at hand last night.
Okay. But you're not the victim?
No,
Right. Okay.
I'm a witness.
Okay. All right.
So she,
Is that the victim? Is the victim here?
no, she's also a witness. She
Okay.
was there.
Okay. All right.
Your Honor, state's recommendation is $5,000 bond based on priors and also the events alleged in the probable cause affidavit. Looks like there was a leather belt, began striking victim several times with it, held her down with both hands against her will. It seems pretty serious. We'd also ask for no victim contact.
Okay. I'm going to do a $5,000 bond. No victim. No
Your Honor,
contact.
do we get to have a say in this at all?
Go ahead.
Your Honor, according to my client, it's been more than a decade since he was in trouble with the law. You have a witness here testifying that my client was defending himself from this aggressive 21-year-old. I don't understand. $5,000 bond seems a bit excessive under the circumstances.
Okay,
We're gonna
I
ask the court to
appreciate the
take a
argument,
pretrial
counsel.
release.
I appreciate your effort, but I'm gonna keep it at 5,000 and, a victim no contact order. Thank you. Pedro Dennit? Counsel? Yeah, that's.
Order 5,000.
Hi, Mr. Dennit, how are you?
Okay.
All
I'm
right.
okay, sir.
Sir, you're charged with domestic violence, which I found probable cause for, and also you have a violation of felony probation, which is a no bond hold. So I'm just gonna ask the state for the recommendation on count one.
Again, $5,000 based on the incidents and no contact. I've spoken with the victim advocate unit, and there are some fears here, so we'd ask for no contact.
Okay, counsel, Mr. Miller, anything?
Again, Your Honor, $5,000 is excessive. I read the PC in this case. It sounds like they got into a fight. This is not, $5,000 bond is excessive under the circumstances, especially considering he has a no bond hold on the BOP.
I'll do 2,500. I'll do a
Thank
2,500
you, Your
on
Honor.
count one and a no bond on count two. You'll see your trial judge in a few days.
Yes, Your Honor, and no contact.
And a no contact order. Thank you. Sorry, State. Mr. Aaron Kwerki?
Didn't speak with him.
This one here.
North Broward.
Yes. Hi, Mr. Kwerki. How are you?
Good morning, ma'am.
Good afternoon. Sir, you're charged with domestic battery by strangulation. I found probable cause. I'm just going to ask the state for the recommendation of bond amount.
Your Honor, there are a lot of priors here.
He had possession of cocaine, 04, fleeing, eluding, grand theft, auto, 05 out of Lee County. He had a domestic violence battery and assault. The domestic violence battery was adjudicated in Lee County. The assault was dropped. Another domestic violence violation probation, 2006. Disorderly conduct that was dropped in 07. A battery in 2007, a conviction.
Okay.
Oh, can I
recommendation?
state, can I,
Your Honor, based on the priors and the strangulation alleged here, the state would ask for $2,500 and no contact.
Okay. Sir, you could say something, but I don't want you to tell me anything about the facts of your case.
I was just gonna ask for ROR because
Yeah,
I'm
you're
like
not going to
really,
get that. Okay. I'm actually going to make it a $5,000 bond. Okay. Thank you, sir.
And no contact?
And a no contact, victim no contact order. James Blank?
North Broward.
Medical reset, Your Honor.
Okay, thank you. So you want me to write that on top, medical reset, or you'll write?
Yeah, just medical reset right here. that
Okay.
line.
Azania Hayes?
Leave it here.
And these are hers. Domestic, she takes it back.
North Broward.
Hello, how are you?
Hi.
Hi, okay, you are charged with, having a false owner info, with pawned items, dealing in stolen property, and, I found probable cause. The bond amounts on each count are $3,500. Does the state have any objection to those amounts?
No, Your Honor.
Okay, so I'm gonna leave it at that, $3,500 for each count. If you could bond out today, that's good. If not, you'll see your trial judge in a few days.
Okay, thank you.
Okay, good luck. Tanyera Morales?
Main jail.
Hello? You can hear me? Okay.
Yes, I can.
Okay, you are charged with grand theft. I found probable cause. Any objection to $1,000, State?
No, Your Honor.
Okay, we're gonna leave it at 1,000. Okay, if you could bond out, you'll get out today. If not, you'll see your trial judge in a few days. Good luck. Kaya Fernandan?
North Broward.
Pardon? Say what? Say what? Sorry?
Hello?
Ma'am, how are you?
Don't say anything, ma'am.
Hello, Miss Ferdinand, how are you?
Hello, good, you?
Good, thanks. Ma'am, you're charged with possession of cocaine and trespass, failing to leave property upon order by owner. I found probable cause. The bond's going to be set for $1,000 on count 1, and there's no charge on count 2. All right?
Okay.
All right, good luck.
Um,
Brittany Prince.
Paul Ryan.
Hi, Miss Prince, how are you?
I'm great, yourself?
I'm good, thank you. You are charged with grand theft, contributing to the delinquency or dependency, probation violation, use of anti-shoplifting control device, and probation of violation. For the two counts 3 and 5, your probation of violation carries with it a no bond. For count 1, any objection to the 1,000? Okay, and
No, Your Honor.
to the 500 on 2 and the 1,000 on 4?
No, Your Honor, no objection.
Okay, so that's what we'll leave it at. We'll leave it at $1,000 on count 1, 500 on count 2, 1,000 on count 3. The others are no bonds, so you'll see your trial judge in a few days.
Okay, thank
All right,
you.
good luck. All right, Mr. Roger Perrin? Hi, Mr. Perrin? Is that you? The main jail?
Okay, thank you.
Roger Perrin is present at the main, Your Honor.
Okay, thank you. Hi, sir, how are you?
Good.
Okay, sir, you're charged with petty theft, and you have 2 capious misdemeanors. So, I found probable cause, and the bonds are gonna be set at 100 for count 1, 50 on count 2, and 100 on count 3. Good luck to you.
Your Honor, Mr. Perrin is interested in resolving these cases should the court be so inclined.
Okay, any objections, State?
Your Honor, state's offer would be an adjudication and credit for time served. Looks like he has some priors, but in New York in 2000, DUIs.
Okay, but with the bonds set for the capiouses were by other judges, right?
Yes, and those are 2 city cases.
Oh, they're misdemeanors?
I'm
I mean
sorry, that is one
municipal.
city case. Yeah.
Municipal ordinance, okay. All right, just so you know, Mr. Miller, the state's offers an
ma'am.
adjudication.
Are you okay with that? Yeah. Your Honor, I was just explaining to him some of the collateral consequences for taking a plea to count 1. He understands them and is willing to go forward on those terms.
Okay,
We don't have any standing as far as counts 2 or 3, so he would be going alone on those.
just raise your right hand. Do you swear affirm everything you say will be the truth and nothing but the truth to help you?
I do.
Okay. You understand, if you resolve your case today, you're going to do so by pleading it out. You could plead no contest or guilty. No contest is telling me you don't admit or deny the charges. It's a plea of convenience, so you could get the case over with today. Or you could plead guilty, which is admitting the charges as alleged. The state's offer is an adjudication, so I would find you guilty. I would tend to agree with the state here and find you guilty, and that would be done without a trial. If you do plead out, you need to understand that you are giving up your rights under our Constitution to have to go to trial, to appeal, to confront witnesses, to remain silent, that everything we do here is final. Do you understand that?
Yes.
You'd be giving up your right to counsel, but you have counsel, so you're not giving that up. Your counsel explained your rights to you,
Yes.
and you understand what's going on?
Yes.
Anyone force you to enter into this plea?
No.
How do you want to plead?
No contest. No contest.
Okay. And are you under the influence of any medication, drugs, or alcohol?
No.
Okay. And you feel it's in your best interest to resolve it today?
Yes.
And just one last time, you understand the rights you're giving up by pleading?
Yes.
Okay, I'm going to find you made your plea knowingly and voluntarily and find a factual basis for the allegations. We'll do an adjudication, and how about a no return to the Publix located at 1415 East Sunrise Boulevard?
Yes, Your Honor.
Okay. And I could lift these capiouses? I mean, these, they're municipal ordinances. Yeah, I could lift them, right? Yeah, to the capious? What do you plead with capious? Okay, so we'll just keep the bond on the capiouses at 50 and 100. We'll just keep those charges, those bond amounts.
Did you resolve?
Oh,
The
well,
state
that's what I was
case.
saying. Could I lift the capiouses? Yeah, I'll do time served on the capious as well. Perfect. Thanks, Clerk. Thank you. Okay, so you're all resolved today. It's time served for everything, for counts 1 through 3.
Thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Nestle Gustave?
He is bonded, Your Honor.
Oh, okay. So you feel right then on the top? Okay. Wayne Lothrop?
Bonded.
Okay, these two are bonded. Rionte Heller? Hi, sir,
Present
how
at the
are
main.
you?
Good.
Okay, so you're charged with grand theft and I found probable cause. So we're going to just leave your bond at, sure? Okay, any objections, State?
No, Your Honor.
Okay, did counsel, you explain that to him?
I'm sorry, I didn't hear what just happened.
Okay, the pretrial release, he's being recommended to go into pretrial release.
Thank you, Your Honor. I will advise him to go there today if he gets out in time, or first
Yeah.
thing tomorrow.
Okay, I'll order it, thank you.
Thank you.
Okay, perfect, thank you. Okay, you understand what's happening, Mr. Heller? You understand
She
what's
wants to know if you
happening?
understand what's going on.
Oh, I'm getting ready now.
I'm explaining it to him, Your Honor.
Okay, perfect, thank you. Edward Samasco?
2019,
Present at the main, Your Honor.
Okay, hi, Mr. Samasco, how are you?
Good, how are you, ma'am?
Good. Is he eligible for pretrial? Okay, that's okay. All right, so you're charged with petty grand theft? Okay. Okay. And I did find probable cause. The bond amount is going to be $1,000. If you could bond out today, that's fine. If not, you'll see your trial judge in a few days.
Okay, thing
Okay,
is,
good luck. All right, Omari Stevens?
Your Honor, you wanted to address the court?
Who? Wait, is that that file?
Go ahead.
ma'am,
Yes?
Your Honor?
Yes?
I live, I'm on my own in New Jersey, or in Florida. Everyone I know is in New Jersey. My family, friends, everybody. So to make $1,000 bail is going to be basically impossible for me because I don't know anybody in Florida.
Okay.
Can
I
you
understand.
please?
You have a pending case in New Jersey as well, so I'm gonna leave the bond at $1,000. If you can't make it, you'll see your trial judge in a few days.
Thank you, Your Honor.
All right, thank you. All right, Mr. Amari Stevens?
Present at the main, Your Honor.
Okay.
He declined the PD.
Okay, thank you. Mr. Stevens, you're charged with robbery with a firearm and fleeing, attempting to elude law enforcement. I found probable cause. I'm gonna let counsel make arguments.
he declined a PD.
Your Honor, state would recommend a no bond hold in this case. There is proof evidence or presumption great. The elements have been satisfied when the defendant admitted participation he was ID'd 100% by the victim and the officer. Under the principal theory, he was there and ID'd to have been there and was in possession of the property and in fact admitted to being in possession of the property.
Okay, I agree with you. I find the presumption of guilt is great and the proof of guilt is evident. It's a no bond hold on count 1 and we'll leave it at $1,000 on count 2. Okay, you'll see your trial judge in a few days, sir.
Your Honor, the defendant is also on probation for 4 cases.
He left. So you're gonna ask for something else?
No, just that he be held no bond on those probation cases as
Okay.
well. Yes, 13-20959 TC 10A, 13-33367 TC 10A, 14-351 MM 10A, and 14-20672 TC 10A.
Okay, there'll be no bond on those cases.
All right, we'll do orders.
All right, thank you. Terrence Jolly?
Yes, ma'am. President
Okay,
Domain, we
sir,
have an argument.
you are charged with attempted murder and possession of a weapon. I found probable cause. I'm going to let counsel make argument.
Your Honor, the proof evident and presumption great essentially speaks for itself here. There is an intent to kill, being shot 3 times at close range. The shots resulted in an immense loss of blood, and the defendant gave a statement post Miranda confessing to shooting at the victim.
Counsel? Mr. Miller?
Yes, Your Honor, I've got this one covered. This is not proof evident presumption great. According to the probable cause affidavit, Your Honor, there was a fight between several individuals that escalated. At best, this is an aggravated battery with a deadly weapon. There is no attempted murder here. There is no premeditated design as pursuant to the statute. There would, in order for there to be, there is no felony involved, so there's no felony murder, so there's no attempted felony murder. There's no such thing as attempted second-degree murder. Your Honor, the only thing that the state can go forward on is the aggravated battery with a deadly weapon. I would argue that there is no proof evident presumption great, and that the defendant is entitled to a bond under these circumstances. There's no other charges holding him, and he's not on probation in any other cases.
Your Honor, the decision to shoot the victim 3 times at close range, I think rises to a level much beyond aggravated battery with a deadly weapon.
I agree. I'm going to do a no bond.
Your Honor, they were in a fight that escalated, okay, because people bring, it was a fight that escalated. It was not premeditated. It was a situation that got out of control. That is not, does not constitute premeditation. It could be a second, if he were to die, it could be a second-degree murder. But again, there is no attempted second-degree murder. That's a crime that does not exist. I would again argue, Your Honor, there is no proof evident presumption great here. It has to be, Your Honor, proof evident presumption great has to be a standard higher than beyond a reasonable doubt. We have reasonable doubt here because there was the fight that escalated. That's in the probable cause affidavit. This is not a violation of probation where it just has to satisfy the conscience of the court that the crime occurred. This has to be proof evident presumption great. This is a standard that is higher than beyond a reasonable doubt. The state has not met that burden. My client is entitled to a bond at this juncture.
2 things. Even if it escalated from a fight, he still deliberately shot at the victim in close range 3 times, resulting in an immense loss of blood. And furthermore, there are some priors. The defendant was released from prison in April
Objection, Your Honor. Priors are irrelevant to the argument at bar. The priors are irrelevant to the argument at bar. This has nothing to do. Thank you.
Okay, but I do find the presumption is great and the proof is evident, so it is going to be a no bond on count 1, and I'll leave a $2,500 bond on count 2. Chavago Walker. Hello, sir. How are you? Did you hear me?
President Domain, Your Honor.
Okay, yes. How are you, sir? Turning it off. Anyhow, okay.
I'm all right.
Okay, good. Sir, you're charged with dealing in stolen property, and I did find probable cause.
Your Honor, he's
Yes?
out on bond on dealing stolen property and 2 counts of grand theft.
He's on, I'm sorry?
He's out on bond on a dealing in stolen property and 2 counts of grand theft.
Okay, on a different case.
Correct.
Okay. All right, what's your recommendation for bonds?
Your Honor, state has no objection to 3,500.
Okay. We'll keep it at 3,500 then, your bond. You'll see your trial
Your
judge
Honor,
in a
he's
few days if
explain-
you can't bond out.
Your Honor, Mr. Walker is explaining that he's already bonded out on these charges. I'm not privy to all of the information that the state would have. However, I would ask the state to look into that.
Okay, we'll have.
If he's already.
Yeah, that's what he's saying.
No. He has other cases, but this is bonded on this.
Okay, so he's bonded out. Okay, all right. Sorry about that. Okay, so he's bonded out. All right, thank you. Julius Clark?
Main jail.
Yes. Hi, sir. How are you?
Hello.
Hi, sir. You are charged with possession of cocaine,
What happened to your head?
battery on an
the
officer,
police.
resisting an officer with violence, resisting an officer without violence, possessing drug paraphernalia, driving with a license, suspended license
You're not
without
gonna get
knowledge,
pre-trial on
and driving
Ag
a
Batleo.
vehicle with unsafe
Batleo?
equipment. I found probable cause, and unless there's any objection from counsel, I'm going to leave the bonds
So why would they
amounts
sign
as
me up for it?
posted.
No objection.
Okay.
To go to Mr. Miller, if you will, on that, Judge?
So why would they sign me? Your Honor, I understand that Mr. Clark has been interviewed by pretrial services. I wonder if he would be eligible for pretrial release on this one?
They're advising the court that he is not eligible.
Very good, thank you. Your
Okay.
Honor, we need a photo order for Mr. Clark.
Okay, that'll be granted. Okay, so we're gonna leave the bonds at 1,000 on count 1 and 2, and on count 3, 500, count 4, 100, count 5, 100, and on count 6 and 7, there'll be no charge. Good luck to you. I just need the order.
This one?
Okay. Okay, Alberto Ramos
North
Picardo.
Broward, Your Honor.
North Broward, he needs a Spanish translator, Your Honor.
Okay.
Called for them.
Timing is great. We have one. Timing was perfect. Hi.
Hi.
Swear you in? Hi. Do you swear that everything that the defendant says to me in Spanish, to the court in Spanish, that you will translate to us in English to the best of your knowledge, and everything you say in English you'll translate to him in Spanish to the best of your knowledge?
Yes, I do.
Okay. And your name?
Esther Imergi, Spanish
Okay.
interpreter.
And Mr. Ramos Picardo? Do you
Señor Ramos
swear or affirm
Picardo,
that
¿jura
everything
usted
you
o
say
afirma
will be
usted
the
que todo
truth
lo
and
que usted
nothing
vaya a
but the
decir va
truth
a
to
ser la
help
verdad,
you?
toda la verdad y nada más que la verdad? ¿Lo jura usted por?
Sí, señor.
Yes,
Sí.
sir.
All right, sir, you are charged with battery on a
se le
person
está acusando
65 years of
Con
age or
agresión
older. I
física
find
en
probable
una
cause.
persona de 65 años o más mayor, yo encuentro motivos fundados.
Okay, I'm going to ask the state their recommendation for the
Voy
bond
a
amount.
pedir al Estado que me dé recomendaciones.
Your Honor, he
Su
had
señoría, él
aggravated battery with a deadly weapon, domestic
tiene
violence,
una
and tampering
violencia
from last
con
year that he's
agresión
out
con
on.
arma mortífera.
He also had another battery in
Y otra
2010.
agresión en el año 2010.
Another 2010, he had another
2010
domestic violence battery,
tenía
strangulation that
otra
was dropped,
agresión, también un altercado que también
Assault.
fue tumbado, agresión.
and he had a DUI in
Y
2007.
tenía un DUI
Another
en el
battery.
año 2007.
Sorry, 93 battery that was dropped.
1993, agresión que fue tumbada.
92, he had a battery on
En
a police officer.
1992, una agresión en contra de un oficial de la policía. 1992.
Yo no estaba guiando.
He could
Yo
put
no
his
he
hand
guiado.
down.
¿Puede usted bajar la mano? I was not driving.
Oh, no, don't tell me about the facts of
No me,
the
no me
case
hable de
or
los,
any of the
de los
cases
hechos
at this
factuales del
point.
caso ahora, por favor.
Que me
Okay.
vaya de mi casa.
Hable
Further,
ahora, por favor.
okay. What is your recommendation for the amount?
Your Honor, state would recommend a $5,000 bond and a GPS monitor. It appears that he keeps coming after this person. She stated that she was in fear for her life and safety, did not give the defendant permission to touch her. The victim is
Me van a
also
soltar.
71 years old.
Y, I'm sorry, what was it?
The victim is
Me van a
also
soltar.
71 years old.
La víctima tiene 71 años de edad. He's talking at the same time in the court and everybody's talking.
Okay. I don't want
Ahí es mi
to...
esposo por 25 años.
She's my wife for 25 years.
Well, yeah,
Por favor, no diga más nada acerca del caso, por favor.
Okay,
Okay.
I'm going to make the bond at $7,500 or a
Voy a fijar
GPS
la
and a
fianza
no
en
contact order.
$7,500
Thank you, Your
y que no tenga contacto con ella,
Yes.
con la víctima.
¿Cuánto? ¿Cuánto?
7,500, how much? 7,500, 7,500, right?
Right, and-
$7,500.
And a no contact order.
Pero ellos me
No.
dijeron 1.500 anoche.
$7,500 y no puede tener contacto con la víctima.
And he'll have a GPS
Y
monitor.
también va a tener que llevar un monitor, un GPS.
Ok. ¿Cuándo me van a soltar?
Gracias. No
Thank you,
puede
sir.
tener
Good
contacto.
luck.
Gracias, buena suerte.
Ok.
Okay,
All right.
thank you, interpreter. You need me to sign your...
No,
Okay.
I just need to know, do we have more cases, Your Honor?
We have 3 more. Bart Jano?
169.
Okay.
¿Habría algún otro caso que necesite intérprete en español?
Oh, yo
¿Alguien
no
más para
necesito-
español?
No.
We're good here at the
No?
bank.
Okay, we're good.
Thank you, yep.
Thank you, Judge.
Thank you. Hi, Mr. Jano, how are you?
Good morning, Judge.
Okay, sir, you are charged with dealing in pawned items, dealing in stolen property, using another person's ID without their consent, and illegal use of credit cards. I found probable cause. I'm going to ask the state for their recommendation.
Your Honor, no objection to the standard bonds.
Okay, so we're gonna keep the bonds at $3,500 on count 1, on count 2 the same, count 3 1,000, count 4 100, and if you could bond out, you'll get out today. If not, you will see your trial judge in a few days, sir. Good luck. Joseph Capello?
Bonded, Your Honor.
Thank you.
Banks,
Eddie Banks?
President of Maine.
Hi, Mr. Banks, how are you?
I want to go home. All right.
Okay, sir, you're charged with possession of cocaine and possession and use of drug paraphernalia. I found probable cause, and
I think there's a girl. Yeah, but we're gonna be.
priors.
2013, he had a 1974 robbery out of Michigan that was conviction. That was old.
You're okay with 1,000, right?
Yes, Your Honor.
Okay, we're gonna keep the bond at 1,000 and no charge on count 2. Thank you, sir. Good luck. Okay, so who is this? What is this? What's this mean? 7 days, 4 days, 5 days?
What was that password again?
Okay. Are these municipal ordinances?
What was that
Okay. All right, Melody Martinez.
All right.
Hello, ma'am.
Judge, this is an MO. She's in 7 days for an open container.
Okay. All right, any objection to having her released?
Who's this person?
Melanie Martinez. Hi, Miss Martinez. You're
Hello.
carrying an open container in public. It's a municipal ordinance violation. You've been in jail for 7 days, so
Yes, ma'am. I also have 4 other cases.
on this case,
No, I have 4 other open container cases that I've been in for as well.
yeah, but for this, we're just here for this, so
They said that they were gonna get all the files together and handle it at once on the 3rd.
okay, I don't know where the other files are, and I don't know who told you that.
And she's
The,
entitled to
first-
counsel, Your Honor, to be appointed special
The first
PD
magistrate
if
judge
she,
that I
if she
spoke
doesn't
with.
work it out.
Okay, if you don't resolve it today, you could get a special public defender. You want to speak to one?
Oh my God. So I have to stay in jail.
You only have one case before us today, ma'am, and the other 3 are not here. The judge is just addressing this one case, the open container, Hollywood case. What, are you making an
Okay,
offer,
so
Judge? Judge, is there an offer if she wanted to resolve this case?
Yes, please.
That goes good with the PD's office, right? You have any objection?
Your Honor, this is a city case. I don't have any information
I'm
on
gonna release
it.
you today.
You'll be released, ma'am, on this
Okay.
case, not the others.
Are you releasing him?
Yes.
ROR. Okay. Okay. You're gonna be able to
Can I
get
get
out today.
Adjudication or
No, no,
time
no, no.
served?
No.
I mean, there's MO already.
Yeah, that's okay. No, no, you just bond, you don't have a bond. I'm just gonna release you on your own recognizance. You've been in
So I would
jail
still
for
have to go
7
back to
days
court?
for a municipal ordinance.
Yes, but I would still have to go to court?
Yeah,
I can't
yes.
I can't resolve it today?
No. I
No.
don't have the information in front of me. I don't have the attorney, the city attorney. So I can't.
Okay, well, how will I get that information? Do you know?
Yeah, in the mail. You'll get a notice in the mail. Oh, you're gonna see Judge Wren tomorrow on your other cases.
Okay.
Okay,
Okay, perfect.
all right, good luck.
Thank you.
Thomas LaPlante?
No, I'm not.
Mr. LaPlante is present at the main, Your Honor. He's here on a petty theft, second look. He's been in custody since November 30th.
Okay. And any priors?
Another
Yeah.
magistrature?
Theft from 2010, DWLS, 06,
That's a
possession
regular
of
judge?
4.
Been a long time since I've been in trouble. I just started.
We can resolve it today if you want, sir. You want to resolve it today? You want to plea it
He does
out?
want to resolve it.
Okay, raise your
Yes,
right hand.
ma'am.
You swear affirm everything you say will be the truth and nothing but the truth to help you?
I do, ma'am.
Okay, sir, I don't have the, PC.
I don't have a copy of it.
So, I don't know if it's probable cause. Okay. I don't have any of the PCs.
They're
Oh, okay. Oh, there's a $500, he has an active capias. He was loitering in a shopping plaza asking people for money, that's a different case. Yeah. Okay. So, I don't really want to resolve it without reading the affidavit, so we can't resolve it today, but, I could give you a bond, if you could bond out. You
For the
okay with
bond,
$100 bond?
I just started a brand new
Okay,
job,
I'm
a
gonna
good
just set the
job.
bond at $100.
I don't have it.
Wait, could I do a bond without probable cause?
I don't have it. Ma'am, if I don't get out, I'm gonna lose this job. I just got a $52,000 a year job. I'm gonna lose it.
It was a capias, you said?
There is no
This is a
case.
2010 case as well.
But this is
Oh,
an
no,
old,
this is the
old.
2014.
No, Your Honor, this is a 2010 case.
Yeah, the first.
I don't have.
There is no new case.
No, it's 2010, sir.
Oh, so you're up on a $500 bond. There's a capias out on you. So that the other judge said it. I can't change it.
That was from 2010, that's why I'm here.
That's what this is for. Yeah. Okay.
I
That's
was
all
here
can do.
Monday, I was here Monday and I was told I would come back today.
You're going to be before your
Ma'am,
trial
I'm-
judge in 2 days. A few days.
I'm gonna lose my job.
Yeah.
I can't because I don't have probable cause. I don't know how to. Okay, I don't have the paperwork to determine probable cause or not. So my hands are a little tied on this one. I'm sorry, I have to go by what the other judge did, and they set a $500 bond.
Come back.
Can you put him on pretrial release, Your Honor?
I don't
Your
know.
Honor,
Is he
please,
eligible?
if I have to sit here the rest of the week, I will lose this job. It took me a long
Hold
time
on,
to
does
get
he have an
it.
address?
Do you have a permanent address?
Yes, ma'am, I've been in Pompano 55 years.
What is the address?
We need the address.
It's 1225 Northeast 25th Avenue, Pompano.
Northeast what?
Northeast, what?
25th Avenue, Pompano. I've lived in Pompano all my life.
Zip code, sir?
What's your zip?
33062.
The court is inclined to release him. You can have it.
For pre-trial?
Yes, he
Oh,
must
yeah, I will.
report tomorrow.
That's fine. We'll release you on to pre-trial release.
Must report tomorrow.
Yep, that's right across, you give him a map.
I'll explain it to him. Thank you, Your
Thank
Honor.
you.
Thank you,
Thank you,
good
Your
luck.
Thank you, Your Honor.
Okay, Taylor Woodley,
All right.
Hello, Judge.
how are you?
I'm fine, how are you?
Okay, you're charged with trespass, you've been in jail for 5 days, it's a violation of, is this a municipal ordinance?
No.
No, okay. So we have the PC on this one?
I don't have the PC, but I do know that she has another open case here in Broward, prostitution.
Okay. You okay with her being released?
You see prior.
The only thing I see is the previous prostitution case.
And we don't see anything but the prostitution case.
Okay, so we could ROR? We're gonna release you today, ma'am. ROR.
Thank you. Thank
Okay.
you.
Stacy Allen? Stacy Allen there?
Your Honor, Stacy Allen bonded.
Okay, thank you. Tony Johnson? Okay,
Right here, Your Honor.
okay. Just tell me when you're caught up. I'm just waiting for the clerks
Are you-
to catch up.
Del
Okay.
Johnson.
Mr. Johnson, how are you?
Oh, I'm alive and well. Thank you, ma'am.
Okay,
I mean,
good.
miss.
Good. All right, so you're charged with trespass and disorderly conduct?
Say it again, ma'am.
You're charged
Ma'am,
with
I mean, miss.
you're charged with trespass and disorderly conduct. Any priors?
Yes, Your Honor.
Okay, I'm just asking
Yes.
the state.
Your Honor, he has, it says some violence in his past, according to what I have, but I don't have a list.
Do you have,
He has a
what kind of violence?
possession of cocaine, criminal mischief, possession of cannabis with intent, the Lewd Act in 2001, possession of cocaine, false
Okay.
imprisonment, battery, 95, another battery, and 94.
And do you have the PC there?
I can try to pull one up.
I'm looking to see if it's been scanned in.
Okay. Oh, sorry. Okay, thank you.
Tony Johnson.
Mm-hmm.
Thanks.
Your Honor, I don't see a PC, however, I do see that a hearing was held, magistrate in,
I have it.
you do have it? A hearing was held and probable cause was found. On the PC,
Okay, was there a bond amount?
disorderly conduct was 0 and trespassing was 100.
Oh, thank you so much. Okay. All right, I found probable cause. We're gonna set the bond at, I'm gonna just ROR. You're gonna get out on your own cognizant. Okay. Pedro Ayala?
Conti, Your Honor.
Okay, you're done.
Okay, so when I come back to court?
Hi, Mr.
You're gonna
Ayala,
have to
how
check
are you?
How you doing, Your Honor?
I'm good. You're charged with making a false affidavit for a driver's license and not wearing your seatbelt. And again, state, do you have the,
Yes, Your Honor.
on a different case?
Yes.
Okay.
And his bond is $5,000, it was up to $5,000.
Okay, so this is a violation of,
I don't, the judge upped his bond from 100 to 5,000.
for the cocaine one?
No.
For this?
For this case.
Okay, so they found probable cause already?
Correct.
Okay, so, we'll keep the bond at 5,000, and that was just on count one?
Yes.
Okay, and the seatbelt, there'll be no charge? Okay, we're gonna keep your bond at 5,000. Good luck, sir. Okay. Ayala? Pedro Ayala?
Oh, sorry. I was on the other one.
He's been held
Oh, I'm
on
sorry.
no bond for possession of cocaine.
Oh, well, then get him back.
$50 for the.
Could we get Mr. Ayala back, please? Because the no bond is a lot different than 5,000.
The no bond is on the, he's here on the KPs, right? TC 30.
Could we get him back,
Yes.
please,
And
Mr.?
mine is set at 250.
Ma'am, he's coming right back.
Thank you.
Yes, Your Honor.
Conti?
Hi, sir. I was misinformed by the state that you were being held on $5,000.
Yeah, I was thinking the same thing.
Yeah, you're really being held on no bond. So it's a little worse for you, but I'm sorry. But so you have you're being held no bond on count one and 2,500 or 250?
No.
And 250 on count two.
Yes.
Okay, so you'll see your trial judge in a few days. Good luck.
All right.
All right, sorry. Thank you. Christine Brown? Okay, I don't have, I don't have anything here, so if you could fill me in as we go, that would be.
Your Honor, Christine Brown, this is a 30-day hearing. She's been in custody. Today is the 40th day.
Entitled to
I've been,
ROR, Your Honor.
yeah, she's
so
gonna be
ROR.
released, yeah.
Edward Christie?
Applies there, it's a
Hi,
30,
sir, how are you?
30-day judge. I've been informed
I'm
that they
fine.
can
I've
speak
been
for
here
the
for
state.
35 days.
Yes, I see that.
They've indicated that they have not filed. He's entitled to be released on his own recognizance, Your Honor.
Any objections, Dave?
No, Your Honor.
Okay, you're gonna be ROR. Danny Watson?
Your Honor, this is also a 30-day hearing. That case
Your Honor,
appears to have been filed
he got
today.
scheduled for PM court. He's down there.
But it's been filed.
It's been
It appears
court.
to have been filed.
Yes,
So
yes.
he's in front of his judge now?
Apparently.
I have no idea, but I know it's been filed.
Yes, Your Honor.
So there's no action. Okay. Clinton Masses?
North.
Today as well, and from what I've been informed, they have an ROR because they have not filed.
Your Honor, I don't see that it's been filed.
And Reynolds Charles?
This is the second look, Your Honor.
Are you looking
In
to resolve?
17 days.
No, you can't. I can't. So what are you looking for, an ROR?
ROR, yeah.
When's the last time you were arrested?
I got it on June 21st. I was 364.
Yes.
What?
I got it June 21st of this year. Did a 364. That's the last time I was arrested.
Okay. Well, this is a new case.
Yes, that's the last time I've been arrested. Since this, 20 June.
She's not gonna ROR.
Or pre-trial release or something.
Tell me why. Convince me. I'll try to convince her.
I have a job that started.
You want to turn
Where?
off the mic, Mike?
Where it
Dale?
improves my old job I used to work.
What do you say? You're talking about 364 on the armed trespass?
Okay, but for this case, sir, you're charged with disorderly conduct and resisting an officer, 2 counts of resisting an officer. This is not for the case that you were in jail for the other case that you got out of. So the recommendation, do we have probable cause? I never had these before.
Your Honor, could we keep the bond set at the standard?
Your Honor, Mr. Charles has been in custody for over 2 weeks on a $700 bond. Clearly, he cannot post the bond.
I always go to my court.
I mean, we're paying $117 a day to keep him here on these charges. If he could afford to post the bond, he'd be out. Can we consider pretrial release for him?
Is he eligible for pretrial release? Does he have a permanent address?
This person would go on pretrial if you weren't.
Yes, Your Honor.
Yes, I do.
Okay, I'm sorry.
Yes, I do.
Okay. Any objection to pretrial?
No, Your Honor. I do have a copy of the PC, though. if
Okay,
you'd like
could you
me-
read it?
Yes. On November 17th, I responded to location in the city of Fort Lauderdale in reference to a physical fight taking place in the middle of the roadway, and one party was armed with a metal chain. Upon arrival, I observed defendant actively engage in physical combat with the victim. The defendant was repeatedly striking the victim in the head with the metal chain, causing multiple lacerations to the face and top of the head. Defendant was swinging the chain from an overhead motion with the intent to inflict the maximum amount of force possible. I gave multiple verbal commands to defendant stating drop the chains, get on the ground. Defendant refused to comply, and I was forced to go hands-on with the defendant for fear that great bodily harm or death was going to take place. During my attempt to place the defendant into custody, he pushed my head back with his hand in an attempt to push me off balance and take control. I delivered multiple strikes to the defendant and was eventually able to place him into custody with the help of my emergency backup officers. Defendant was transported to Broward General Hospital for his injuries. While at Broward General, the victim stated he did not want to prosecute.
Okay, I find probable cause. And we're going to send you to pretrial release. Okay.
Your Honor, thank you. I will instruct
Thank you.
him.
Good luck.
And we're here at the main, Your
And,
Honor.
you'll do the
We also
report
do
on
no
Jolly,
victim
right?
contact.
Yeah, and a no victim
Yeah.
contact
Yes, I will.
cancel.
Thank you.
No, it's not ROR, it's just pretrial release. Okay, then ROR pretrial release. Okay, thank you, everyone. Thank you
Stop
for
by
your
my
help.
office, Dale.
Ma'am,
Yeah?
Conti has one more.
Okay.
So-
Who is it?
Jaros Edwards.
Okay, I don't have any information on him.
He's on the second docket.
Do you have anything?
I have that it was a second look from Eric.
Hi, sir, how are you?
Good afternoon, ladies.
Okay. It's a second look misdemeanor. Okay, so you were charged with exposing your sex organs in public and disorderly intoxication in public. I'm just going to read the PC now. The affidavit. Dispatched.
Oh. You're so
All right, Mr. Jarash, I found probable cause. And, what could, you just inform me what happened at the prior hearing? Oh, the bond was set at 5,000, I see. Okay. I'm gonna keep it at 5,000 and there'll be, no charge on count 2. You have a $5,000 bond.
Couldn't you reduce it to 2,000? I could bond out today.
No, I cannot do that. Thank you, sir.
How about pretrial release?
Not today. Thank you. All right, good luck. Could you give this back to? Thank you. Thank you for your help.
Thank you, Judge.